So, Ioannis, thank you for this. This
you.
was a very interesting panel, and I was privileged to be a speaker in this panel. And as the moderator in this panel, what was your particular take on the topics that were discussed? I'm particularly interested in your take on the use of presumptions in merger control. Is it warranted? Obviously, you may not be at liberty to share your own views on this, but with your mental impressions of the panel, what would you say was the added value, the interesting bit?
I think it was a quite interesting panel, and we brought in people from the competition authorities, the private bar, economists, and lawyers. And of course, the issue of presumptions is an important concern, an issue that we are dealing with, not necessarily because of the US and FTC merger guidelines and the Canadian somehow bill, but also a few years now there has been a discussion about developing presumptions in the context of mergers by gatekeepers. If I remember well, that was a suggestion by Belk a few years ago. There was also a paper by Tommaso Valletti as well, taking the perspective of presumptions. And I think when you think about this issue, it's how you deal with uncertainty. I mean, it's more about if you have actually a area of uncertainty in terms of you don't really know what are the effects of technology, and therefore you don't really know what are the effects on the market because you cannot necessarily determine. But at the same time, you have the gut feeling eventually that a merger and a concentration in this might raise some concerns. And eventually, because you have already a specific, type of threshold that you think is important, then it might make sense to eventually have a shortcut, analytical shortcut, and the presumption is taking that perspective, and arrive to a somehow phase where the parties will have to explain what were the main drivers of this merger. And I think, as you rightly mentioned, I mean, there could be pro-competitive or eventually anti-competitive reasons for that rationale for the merger, but it's probably the parties that will have most of the knowledge and the information available to make that. Now, however, and I think this is quite interesting, what you mentioned, you have probably to be careful about the possibility of an asymmetry here. In a way, you need to eventually, and I can hear that argument, give the parties more potential to rebut this type of presumption, to be more open in the rebuttal of the presumption. But again, it's something that, as we probably have seen, also in the discussion of the in the first discussion in the morning between the enforcers, facts matter. I mean, this is a case by case really analysis. And the conclusions we'll be able to reach out of the parties' internal documents, eventually their explanations, might vary. I mean, because of also the different market conditions. I mean, in terms of consumer demand, etc. So I think this is something. So even if you have presumptions, it doesn't necessarily lead to automatic form of fanning of anti-competitive effects. You can still play with more openness in the rebuttal of these presumptions, and enable basically the firms to make arguments to justify, to show that there's no anti-competitive first, or secondly that there are efficiencies that can outweigh these possible anti-competitive effects.
In the panel, one of the points I raised per your question as moderator about what is it that is special about AI. One of the points that I raised was the acqui-hires matter, and the fact that while talent acquisition might be a mundane thing in many other markets, as far as pure breed, real artificial intelligence engineers and technicians are concerned, there may not be that big a portfolio of people, and by way of partial integration, there may be a triggering of the results of what we would call a concentration. And certainly the CMA seems to be taking that view, or at least be entertaining that possibility. So just 25 days ago, they have opened a new investigation. Now, obviously, because of your position at the court, you cannot talk about the Microsoft specifics of it. But academically, it was discussed in the panel that there is something particular about the AI markets and the HR issues. Would you believe that that is interesting, and that partial integration and full integration are now fighting with each other, and new modes of asserting influence might be happening in these innovation-intensive markets, particularly AI ones?
I would not like to comment on the AI dimension and on the issues that you raise, because, of course, these are issues that might, come to the court. But let me say that this is a discussion that is not very new. I mean, in terms of, thinking about partial integration, this is an effects on innovation. I mean, this is the same type of issues we have been discussed concerning common ownership literature the last few years. And there have been a number of papers, and I think Oliver mentioned one by Florian Ederer.
Yes.
But there have been quite a few also papers looking to the innovation effects of common ownership. And to my understanding, but I'm not an economist, the conclusion is not necessarily the same concerning innovation effects as with price effects. So they are more ambiguous in a way in terms of innovation effects, common ownership. So I guess same type of arguments could be made in this context as well. And of course, labor markets is extremely important to deal with. I mean, in particular, thinking about these very highly specialized markets where you need, important years of training, important investment. You don't necessarily have a lot of people out there. I mean, although this is an empirical question. I mean, is there availability of AI experts? Is this really, do they have a sort of non-competes in the agreements? Is there anything that blocks other competitors from using them? And these are issues that could be explored. But I mean, you think about a merger that has somehow this aspect, is the CVC Ethniki merger at the European Commission, which somehow had to deal with the doctors. I mean, doctors are also, something which is extremely, you need to have a lot of investment of time, to train, to be specialized in specific type of field. And if I remember well, I mean, the commission explored if, these doctors were multi-homing. I mean, they were also had exclusivity agreements with the hospitals they were working for, or, they were somehow multi-homing in different hospitals. They found out that they were multi-homing, therefore they did not raise this labor concern. But here it's a little bit different because, I mean, these are employees. But again, one might have this same type of approach, looking to the how, is it possible for these specific type of employees to move to a different company.
Last question, an issue that we have discussed in the panel as well, but briefly because we had such a huge agenda to cover, sustainability and the impact of sustainability concerns on merger control. Now, I mean, I've been a practitioner for 25 years, and I've, been closely linked with the debate in competition law spheres. And constantly, I also deliver speeches on sustainability and merger control. But between you and I and the audience, are you seeing enough of sustainability argumentation in the merger control context? Or is it a real thing that we in real life see? Or are we getting prepared to something that we think is going to happen in the future? Because while academically we keep on discussing this, I see very little debate on it in actual files, and even in some files that suggest that discussion should happen.
Well, I have the same impression, and I have to say it was a little bit of a surprise for competition authorities because, when we started this debate, there was a lot of push from the industry, but also from sustainability groups that this is a major concern, that this could be an issue that could, competition risks, could actually lead to a number of, sustainability promoting type of deals not to move forward. And so far, also in the antitrust field, I have to say, in terms of, because, some jurisdictions provided more possibilities to come up with sustainability defenses. In Greece, we developed the sustainability sandbox. We had actually specific provision for no action enforcement letters. We haven't really seen much activity. Now, the reason is probably it's too short time to judge. I also have to say that all these national initiatives in the Netherlands, in Greece, predated the Commission's guidelines. So no one will move before the Commission somehow has arrived to a certain clear view about this. So it's probably too early to judge, but yes, it's not as important as it was, at least when we've been discussing. And true, sometimes, but probably this is a lack of knowledge, maybe by lawyers, or the fact that there's not any more consultants, economic consultants that could make these arguments. Because sustainability economics is not the IO economics. Environmental economists are not really part, for the time being, of the economic consultancy. So it's a new group to integrate it on our tribe in a way. So maybe we have to wait a little bit longer for these type of arguments to be made. But I remember a couple of times where, we had these issues, and I actually raised a concern myself, to ask the parties, what do you think about that? Rather than the parties come up with a specific type of argument. And so I think it's certainly something to focus on in the future.
This is interesting.
And promote the learning. And I think, having cases, and there are cases now, in particular in the Netherlands, in Germany. We're probably going to see more cases now in the food value chain because of the new guidelines adopted in December concerning Article 210A of the CMO regulation. And I think, these type of cases will probably lead to spread out the knowledge and have more, sustainability defenses. But again, I have to say that sustainability is not just a defense. It can also be a sword in a way. And I think, we have a couple of interesting cases coming up taking this perspective in national competition authorities about how, a specific conduct might eventually affect, which restricts competition, of course. This is absolutely key. Still has, effects on sustainability, and that could be of concern.
With transaction parties, or counsel rather, not making use of the exemptions available, I have a different view in the sense that I think the exemptions are inadequate at the moment, and it's not giving enough of a safe harbor. And the safe harbors are still leaving counsel at a point of limbo, so I can understand why they're waiting. But in terms of not seeing enough of argumentation in the merger control field, even in files that are really inviting sustainability arguments, I think one of the two explanations that you have given should be applicable, because we know that it's not because the importance is not there, there is a need. Either the expertise has not seeped into the merger control filing handlers' sphere of influence yet, so they don't see the argument being available, or alternatively, it may be that they're feeling it's going to confuse the file and it's going to make them look desperate because they feel sustainability is a last resort kind of an argument. If you're failing on everything, then it's a carte blanche. It should not be. Exactly.
No, I think you're right. I think there might be these possible explanations for the lack of having this type of sustainability arguments in merger control. And I have to say, I think having this discussion today about sustainability concerns in merger control is also starting a little bit this, important issue of, expanding the approach that we have in antitrust in merger control. Some will actually be a little bit more concerned by saying, merger is the ultimate type of, agreement, in the sense that you agree to be one, and therefore we have to be much more cautious about sustainability. But again, it's interesting to pose the question and see, if we can have an analogy in merger control with what happens in antitrust and the effort we have been doing the last few years in antitrust on this issue.
Perfect. Ioannis, thank you very much.
Thank you very much.
Appreciate it.
Pleasure.
Take care.